his notes.
SJC-11616, Commonwealth v. Amanda Kelly and others.
Okay, please proceed. Please proceed.
Good morning, Chief Justice, Associate Judges. May it please the Court. My name is Kirsten Zwicker-Young, and I represent the appellant in this case, Amanda Kelly. For this morning's purposes, I'll be arguing approximately 7 minutes, and I'll be focusing on the issue with regard to the judge's instruction and supplemental instruction under Section 39 in this case. The matter before the Court presents us with a need to examine the application of the hate crime statute here because of the important questions raised by the jury in this case and the absence of any authority to properly address those questions.
Now, let me just ask you a question. When the final jury instructions were given on Sections 37 and 39, were there any objections?
No, there was not.
So the only time that there was an objection raised was as to the way the judge proposed to answer the Section 39 question.
Correct. Correct. And this is not a case where we have a victim who was walking down the street and attacked by unknown assailants because of his race or because of his religion and sexual orientation. And those two words, because of, resonate here as words to be defined, understood, and applied. On the night of June 12, 2008, a group of young people, including the appellants Kelly, Shadid, and Bratley, came together as they had many times in the past as friends and acquaintances to socialize. The evidence at this trial demonstrated that it was undisputable that Taziah Robinson was an aggressor on that night, using words such as whore and cracker before spraying a crowd with mace.
Well, was it mace or dog repellent?
It was interchanged during the course of the trial. My understanding was ultimately it was dog repellent, acting similarly of mace when he sprayed the crowd, burning their eyes and their mouth. The crowd's response to this case, while excessive, we would argue is not instigated by race.
Okay, well, the jury, though, found that it did. The only question is the appropriateness of the jury instruction, correct?
The jury found that it did in the realm of the instructions that they were given by the court that we would argue are faulty instructions,
Okay.
particularly the supplemental instruction.
Let's focus on that, because that is ultimately your claim. You speak of this as a causation element, but isn't it more of an intent element? I mean, do we need to know that the assault was caused by race when the language of the statute is with the intent to intimidate such person because of such person's race?
I would argue that the specific intent instructions, if that's what Your Honor is indicating, given by the court, has more to do with the actions. And the jury's confusion in this case came about when they looked at the application of the instruction as it relates to the words because of. It's more than just the specific acts of the defendant, but the acts, according to the statute, had to be because of. The motivation of the defendants, in this case, must be examined. It could not be as the result of their anger over the defendant because he maced them in the face.
But why does it have to be solely because of?
And that's the very question that we struggled with during the course of this trial, and we feel the judge in this case addressed faulty with the jury. And we're not arguing here before this court that the cause of the bias has to be or the cause of the assault has to be solely because of the defendant's bias.
No, but the intent, why does it have to be solely because of race?
Well, we're not arguing it has to be solely because of race, but we believe, in strictly construing the statute in this case, and Section 39 differs itself very greatly from Section 37. Section 37 is much broadly construed. Section 39, however, is very implicit that the actions, that the assault has to be because of an individual's race, creed, ethnicity. It goes on to give a lengthy dissertation of what the particular protected class of individuals must be. So in order to examine the strict construction of the statute, the jury, we believe, struggled in this case with, if it doesn't have to be solely the cause, does it have to be the substantial cause, the predominant cause?
What did you suggest to the judge as an alternative instruction?
What I advised the judge at the time was to respond to the jury that it doesn't have to be the predominant cause was inappropriate. There was no authority that we had to glean to at that point in
So
time.
you made no suggestion as to what the judge should do?
I did not suggest to the court that substantial or predominant should be exercised.
That's something that gets suggested for the first time on appeal.
That is correct. The Commonwealth has asserted that perhaps the Stevens case would be a case to reflect to, but we would suggest that the Stevens case, again, is under Section 37 and not Section 39, a much broader statute. In the Stevens case, there was language that the deprivation of civil rights contemplated under the statute does not have to be the sole predominant purpose. But again, here, Section 39 is quite implicit, so it stands to follow that if the victim's inclusion within a protected class must be the substantial, central, or motivating factor, otherwise the crime is not being committed because the victim is black, because the victim is homosexual, or otherwise. So that substantial motivating factor must be the issue that the jury must struggle with in a particular case. In Commonwealth versus Barrett, that case stands for the proposition that it is not the conduct, but the underlying motivation that distinguishes the crime in this case. In the lineage of cases that come before the Kelly matter, Barnett, Zawadzki, and Pike, we see cases here where there is an absence of another motivation for the crime. In those cases, there are racial bias and slurs being hurled about, in addition to malignant commentary, such as, "Are you having a lover's quarrel? Go back into the closet and stay there. You come to get our jobs and our houses and get out of this country." In those cases, the jury found sufficient evidence to support the conclusion that the defendants were acting out of hatred for the victim's inclusion within a protected class. And in those cases, there was no other motivation for the crime. In this case, taking out the racial slurs, the case stood on its own.
How can you take out the racial slurs?
Now, my suggestion to you, Your Honor, is that if you take out the racial slurs and the connotation in this case stands on its own because of the facts. The facts of this case present that Isaiah Robinson was an aggressor that night.
That's one view of things.
Are you suggesting self-defense?
No, I am not. No, I am not. But I'm suggesting that the jury had to comport the facts of this case, a clear motivation by the defendants why they violently engaged the victim in this case, with the words being hurled, to determine whether it was the words or the other situation that was the motivating factor here for the assault in this case.
But why do you assume that there has to be only one motivating factor?
I do not. But I think to properly construe the statute, it can't be a negligible factor. And that's what the judge did by answering the question only part way. The jury came back and asked the judge, is this the sole, should we consider race as the sole factor or only a partial factor? When the judge answered simply, you don't have to consider it the sole factor, he didn't resolve the confusion. Then the jury is left with the possibility.
Didn't he reread the elements of the statute to the jury and then state, to answer your question directly, the Commonwealth must prove beyond reasonable doubt that the defendants did this act with the specific intent to intimidate the alleged victim because of the alleged victim's race, etc. But this reason does not have to be the sole reason for the assault and battery.
That was the supplemental instruction, and we would argue it was incomplete. It removes the issue as to whether or not it has to be the sole motivating factor, but doesn't resolve the confusion as to whether or not, and this was off of the jury's question, a partial motivating factor, a substantial motivating factor, or merely a negligible
The jury's
factor.
question was assault and battery for purposes of intimidation, solely because of race or in part.
Correct.
Why doesn't the judge's instruction specifically answer that question?
Because it doesn't specifically address whether...
Does not have to be the sole reason for the assault and battery.
In part, it's okay.
That's not what the judge said. The judge only resolved the issue as to whether or not it had to be the sole motivating factor. He didn't address or speak to the jury about whether or not it had to be a partial motivating factor.
Well, what if the judge has said it could be 1% of all the motivating factors?
Well, I would suggest
Would
that...
Would that be incorrect?
It would.
Why?
Because I think to strictly construe the statute, to say that the statute was intended to punish negligible behavior would not be upholding the law.
Well, what if the judge had said 5%?
I don't think a judge would have addressed the issue of percentage-wise, but I think an instruction that would have at least said substantial, a primary, an important factor, would have been beneficial to the jury in this case.
Are you equating cause with intent?
No, I'm not.
Are you distinguishing cause and intent?
No, I'm looking at the use of the terms in the statute because of, and suggesting that to the court that the trial judge failed to properly define it to the jury when they asked it to be defined. And other jurisdictions have struggled with this question. A California case, People versus...
Right, but in California, that's my concern. California was focusing on causation and speaking of substantial factor as what is used in causation. But as Justice Spina notes, this is a specific intent element, not a causation element. Doesn't that distinguish this language from whatever California may have?
Well, California was struggling with the language issue, and in their findings, they indicated that the bias motivation when multiple concurrent causes exist must be the substantial factor in bringing about the offense.
That sounds like tort language.
Perhaps they're using some of those principles there, but it's nonetheless to define to a jury, to define in the law what those words "because of" must mean. You look at the Mitchell case. The Mitchell case indicates the defendants should be intentionally selecting the victims because of their protected status. That's referred to repeatedly here. And in cases such as the Kelly case, where there are multiple motivating factors here, the jury has to look to what was the primary factor. And if we don't tell them that, it could arguably be just a negligible factor, and that is not what Section 39 was intended to prosecute. It was intended to prosecute individuals whose prejudice would be a substantial primary motivating factor in the commission of violent crimes upon people who are part of a specific protected class.
All right, thank you. I think your time is up. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Megan Tate Fedekakelum, and I represent Defendant Christopher Bratley in this case. Mr. Bratley is in agreement with a lot of what Attorney Young just argued. However, his position with regard to the instruction on the hate crime statute is slightly different in that he felt that the judge erred in the supplemental instruction by giving it at all. That there was no precedent that expounded on the because of language with regard to the hate crime statute, and that it went simply beyond mere interpretation on the judge's part, and that he actually created a standard of proof that was not otherwise there. With regard
Are you
to
saying he shouldn't have given an answer to the question, or this was the wrong answer?
Well, I would say that the correct answer would have been simply to reread the statutory language, which I think was suggested by the defendants below. The legislature had not explained what they meant by because of. Certainly, they could have used additional language such as, solely or in part because of, but did not do so. And the appeals court, although they did give explanation to the intent requirement where there was some ambiguity in the civil rights statute in the Stevens case, they did not do so with regard to the hate crime statute, and arguably had the opportunity in the Barnett case, which came after Stevens. There was simply no precedent with regard to interpreting the because of language, and the judge, I would argue, exceeded his authority by establishing a standard of proof for the jury.
Well, that's only true if it's the wrong standard, right? I mean, he's got to answer the question.
Well, I would argue that there's not always an answer where there's been no precedent set. I mean, the jury would have to interpret the because of language in the same way that they had in prior cases. I mean, I think often juries are presented with a situation where they have to interpret a term such as, for example, reasonable doubt. Although there's a definition for it, it tends to be an ambiguous term, and the jury it's their job to interpret and apply. The judge, I would also argue in that regard that the judges, and I don't want to overlap, but the judges applying in the Stevens case was improper, where the judge essentially framed his position as one of having to apply Stevens or having to apply sole motivating factor, and there's a whole range of degrees of the intent in between which could have been applied. And I believe my brother counsel is going to talk about substantial factor test going forward, which is what we all agreed should be the appropriate factor going forward. Before I wrap up, I just did want to draw the court's attention to Mr. Bratley's argument with regard to the hate crime statute. He also argues that the assault and battery associated with that charge was duplicative along with the 2 other assault and battery charges. And that's an issue that was only raised as to Mr. Bratley. I will not re-argue that beyond what was in my brief. It's pretty extensively briefed, but I wanted to draw your court's attention to that.
I gather there was no objection at the time of the jury instruction. There's no request for a unanimity instruction, correct?
No, there was not, Your Honor.
Did the judge give any unanimity instruction as to which acts constituted assault and battery in the final jury instruction as to any of the crimes?
I'm sorry, Your Honor?
Did the judge give a unanimity instruction as to which acts constituted assault and battery in connection with any of the...
No, there was no assertion that they had to be based on separate and distinct acts.
And none was requested?
No, Your Honor. However, in light of the different conduct that was alleged to have been committed by the defendant, particularly where there were said to be 2 different attacks, there were 3 different assault and battery charges, and it was never clarified on the record what conduct went toward which charge, which is the basis for that argument. Thank you, Your Honors.
All right, thank you.
May it please the Court. Good morning, Your Honors. Thomas Foley for Kevin Shadid. I'd like to start by addressing the reported question. Specific intent should have no impact on this case. Chief Justice brought up specific intent in the California cases, but it's important to note the California statutes at issue were in specific intent crimes. In fact, the first California case that I rely on, In re MS, the 1995 case, was the case where the California Supreme Court decided that their civil rights statute was a specific intent crime. But then,
I'm sorry, but isn't it the case that when we have a statute that talks about somebody doing something with some intent and uses with the intent to, that we consider that a specific intent crime?
and this is a specific intent
I thought
statute.
you were just saying it wasn't.
It is, and so are I'm saying this is, and so are the California cases. The California cases specifically said that their civil rights statute is a specific intent statute, just like the Massachusetts statutes are. But the California cases nevertheless go on and talk about the because of language. You could have a specific intent to do 2 different things. We know that because as the law stands now in Massachusetts, you can have a specific intent to violate both of these statutes. So you can have 2 different specific intents.
Well, I understand that, but I mean, you may have a specific intent to kill and also a specific intent to humiliate or other, but we don't basically say that we don't require that the specific intent to kill be the motivating intent. It's sufficient that there was an intent to kill.
Correct, Your Honor. But in those statutes, we don't use the words because of. We're not asking the jury to decide what the motivation was. They're asking to decide what was the specific intent that caused this person to do an action. In this case, in these cases, the specific intent to intimidate, the specific intent to injure. Then as all the cases, not just California, but every other statute that's looked at this, goes on and then addresses really the second part of the specific intent question, specific intent because of. So what does because of? Because whether it's general intent or specific intent, you can have 2 different intents. If it's not a mixed motive case, none of this is an issue. I submit in Massachusetts, if it's not a mixed motive, then you can have, it's really a but-for. I think because of becomes a but-for test. And the
Why
California,
isn't this just a but-for?
well, because when you say because of, and there are
in
no
Burrage, Justice Scalia says that the common understanding of because of is but-for.
And I think that's a very good argument that we could have made. We could have been standing here arguing that you should adopt a but-for test. Burrage, the Supreme Court, is now interpreting because of type language as but-for. And one of the cases relied on by the amicus brief, Wisconsin versus Miller, rejected substantial factor in order to put on an even tougher burden for the Commonwealth, which is but-for.
Is it tougher? It just means it wouldn't have happened otherwise.
When there's only one motive, well, if there's 2 motives, it's definitely tougher. Because now the jury's got to decide, well, which one was really the motivating factor? Did he do this to retaliate, or did they do this because they're racist? And the jury would have had to decide. But they didn't have to decide that the
They
way.
did, because the judge said because of.
But then interpreted because of is meaning it can be more than one factor. So when it's more than one factor, can something, and this is really the question, how are we going to interpret because of? And as all the case law points out, it can be interpreted a lot of ways, but for substantial factor or some de minimis amount. And the jury isn't getting any.
De minimis and but for don't go together.
No, I know. They're opposite ends of the spectrum. But because of could mean either one, or it could mean something in the middle.
Oh,
like
I think
substantial
that,
factor.
I think in Burge, Justice Scalia is pretty clear that that's the common understanding of because of, is but for.
Hey, if we were going to use a but-for test, then I think we would have won this case. I think because when you've got mixed motives, California instructs that is but-for when there are not mixed motives. When there are mixed motives, you can't just say but-for because it's one or the other. Yet our case law tells us it doesn't have to be one or the other. The Stevens case, which is the case that this judge, the only case this judge had as guidance, said that it doesn't have to be the sole or predominant factor. Well, then it begs the question, if it doesn't have to be the sole or predominant factor, then what does it have to be? And the jury was given no guidance.
You may have done this and I'm just forgetting, but is there in any of these briefs an examination of the legislative history of this, of 39?
No, the amicus might have touched on it, but I personally found the amicus brief not helpful at all. They were.
Well, anyway, but you haven't done it.
No, Your Honor. And even the California cases, they don't. The legislative history, it really is just coming down to because of. I really think this is an easy case to decide. It's what does because of mean? And I know my time's up, but if I could just finish on this one thought, I think we can all agree that we would not want a defendant being found guilty of a hate crime if his racial motivation was insubstantial. That's all we're asking this court to decide is don't allow defendants to be convicted of this crime if it's insubstantial. Give a substantial factor instruction, and that fear goes away.
Right, thank you.
Thank you, Your Honors.
Good morning, Your Honors. Kristen Freeman on behalf of the Commonwealth. May it please the Court. With regards to what I labeled as issue 2, which is about the substantial factor test, that's all of Mr. Shadid's brief, Mr. Bratley's issue 3 and 4, and Ms. Kelly's issue 3 and 4. I would cite for a number of reasons that the judge was correct in answering that question. This case is a case of specific intent. The hate crimes were designed to protect certain classes of people. When we have a specific intent instruction, much like the one that was given in this case, it eliminates people who just have mere thoughts or maybe a passing statement that they might say that's racial. So the legislature, in order to protect even constitutional purposes, we wouldn't be able to get over the hump if somebody were to say something in passing, or they might be racially biased, and they do say something in passing. They need to have formed the specific intent to intimidate because of race.
Can I ask you, did the judge give the model jury instruction?
I think it wasn't written at the time, is that right?
I know that the Commonwealth had requested a certain instruction. I believe Mr. Bratley had requested some language, and I think they incorporated those together, and that's the language that he gave.
Okay.
I believe that's what had happened. So the legislature, in having specific intent crimes, didn't seek to punish people just based on their thoughts. So having the specific intent was enough. We don't need a substantial factor analysis because the specific intent gets us there. Causation is not the issue, as Chief Justice Gantz had indicated. If it were something the legislature wanted, a substantial factor, a sole factor, they would have written it into the statute. They've done it before. I've cited cases in my brief, Heath and Strahan, where they say sole or only purpose. That was not done here, and I'd suggest that was done for a reason. Secondly, Massachusetts law permits multiple intents in cases, and I cited those as well in my brief. Rosario, Lazier, Dominique. The precise amount of motivation should not be a factor. It would be tough to judge. And it's exactly like assault with intent to murder, assault with intent to kill, assault with intent to rob. Do you have to quantify the intent in those cases? You don't. And I'd suggest this is exactly the same. You should not have to quantify the amount of intent that they had. If they had the intent, then that was enough to establish the crime.
I mean, you would agree, would you not, that has to be some minimum? I mean, or don't you? I mean,
Well, I'd suggest the minimum is conveyed in the specific intent, that when
the
they...
specific intent to intimidate because of...
Because of race. Right. So I'd suggest that they had to have formed some intent, and it doesn't matter how small, I would suggest. As long as they formed some intent, that's enough.
But they could have, I think that the question arises because they could have a specific intent to intimidate for a variety of reasons.
Right. And I would suggest, even in this case...
And the only one that counts under the statute is the reason having to do with race. I mean, for the purposes of this case.
Right, correct. And in this case...
But here, they say there's evidence of a couple of reasons, at least,
Right.
to have a specific intent to intimidate.
And even to take this case for an example and say 10% of their motivation was race. 10% was, I don't want a stranger, I don't know you in Marshfield. And then some percent was...
10% was xenophobia, and 10% was...
Yeah, they want to be a bully. I want to act tough. That 10%...
10% because you've insulted us.
Well, the 10%, no, and I would disagree with that, because the recitation of the facts in each of the briefs, I would suggest, most respectfully, is in the light most favorable to the defendant. And if I could, just briefly with regard...
But hold on, just theoretically, let's say there was 10% because of what Justice Lank is saying. I mean, whether in fact there was or not, but just theoretically, 10% of this was because of being very angry at having been insulted. If that were true.
Okay, if that's in the scenario, if they still formed the intent to intimidate him because of his race, we still have a conviction, I would suggest, because the specific intent gets you, again, over that hump, that regardless of the other motives that they might have, if they form that specific intent to intimidate him because of his race, then they have proved the crime.
But you agree there must be motivation. It must be motivated at least in part by race.
Because of race, right.
So if it was somebody who was simply teed off because he saw a person spraying dog repellent at a friend of his, that would not be sufficient unless it was motivated in part by the color of the person's skin.
Correct, and I would suggest, too, that he does not, even if he were the initial aggressor in this case, which I would suggest he was not at all, he does not lose his constitutional rights. If he sprays them first, and then the facts move along, and they decide they're going to call him the N-word, which they did multiple times in this case, and their intent was to intimidate him based on the race. He sprays them, and then they start to say the N-word. He starts to back up, and there's 15 to 20 people coming at him, and he's trying to keep them back by spraying the mace, and it's not until the mace runs out, he's converged upon, and he is beaten, he is kicked, he is punched, he's spit on, bottles are broken on him, a stick is viciously being hit over him. The N-word is said by Christopher Bratley, Amanda Kelly. There was testimony that it was said from the end of the driveway to the restaurant where the severe beating took place.
Can I ask you this?
Sure.
Leaving this case aside, leaving the facts of this case aside, someone assaults someone else. There's a crowd around, and the crowd responds and beats the initiator of the assault badly. Is that person exercising some right? The aggressor, I'm saying, is that because this? I'm looking at Section 37, and you're essentially the question of whether one is interfered with in the free exercise of the enjoyment of any right if they are assaulted in response to them assaulting someone else.
So if the victim, so to speak, starts a fight.
Right, starts beating on someone, and the crowd happens to be friends with the other person and converges and pummels him, and he's either a different religion and maybe there are comments made or a different race in the course of that pummeling. Is he being intimidated in the exercise of an enjoyment of a right?
I suppose it would have to depend on more factors. What was being said? Was anything being said?
So the question is, what was being said makes a difference between whether he was
I would say
being
what was
intimidated in the course of exercising a right?
What was being said coupled with the acts. I wouldn't suggest that he loses his rights if he's the initial aggressor. I'm not sure with the facts that you suggest that I can necessarily answer it.
Well, put it in this case. Let's assume that the victim in this case was indeed the initial aggressor. I don't think the facts support that, but there was a lot of confusion going on. There was a lot of back and forth going on. Would you say that if he was assaulted in response to an assault that he perpetrated, that would be an intimidation in the course of his exercising a right, constitutional right?
I would suggest he never loses his constitutional right.
What? Constitutional right to what?
To access to the public street or his personal security.
But isn't that the right here, at least as argued, was the right to be the personal security? I mean, the right to be
Right.
safe, personal safety. Yeah.
Does that mean? Well, let me ask you this: do I have a right of personal security?
Everybody has a right of
So
personal security.
if Justice Cordy were to swing at me now,
Later.
which he would be probably entitled to do based on my conduct, would that be a violation of Section 37 because he's violated my right to personal security, even though the motivation was purely personal?
Well, no, because...
So what is this right of personal security if it does not include every assault?
Well, we would need the assault and battery or assault or battery with intent to intimidate.
No, we're under 37 now.
Right.
Under 37.
Oh, under 37.
Under 37. I'm trying to figure out what this right of personal security is. It was defined by the judge to say a right of a personal security is the right to be free of racially motivated violence. Is the right of personal security the right to be free of racially motivated violence, or is there a right of personal security which would include every assault?
I would suggest it's every assault because, as it reads, it's shall by force or even threat of force. There doesn't even have to be a touching in that case. Willfully, there has to be a willfully injure, intimidate, or interfere with someone in the free exercise or enjoyment.
So
of
every
any right.
assault is a violation of 37?
I'm sorry?
Every assault is a violation of 37?
Only if they're in the free exercise or enjoyment and they willfully injure.
Yeah, well, if I willfully strike the Chief Justice, trust me, it's okay.
It's not Wisconsin.
If I willfully strike the Chief Justice and thereby interfere with his security, why haven't I violated this statute as you've interpreted?
Well, again, I think if you have the specific intent, because specific intent applies to 37 as well.
Specific intent to do what? To violate his personal security by striking him?
To willfully injure or intimidate.
Or assault?
Yep, or oppress or threaten.
I mean,
Right.
it seems as if Section 37 has been interpreted as a way to, where there was no Section 39, but was Section 37 interpreted too broadly? Should we be, and if you interpret it narrowly as the judge did, is it not exactly the same crime as Section 39 and therefore duplicitous?
They're similar.
Are they duplicitous? Should we knock out one?
I would suggest not.
And why not?
With regards to, excuse me, just, I have hashed through this as well, with regards to 37 and 39, because they are quite similar. 37 does not require an assault or a battery. It could be a threat of force. 39 requires an assault and battery plus the specific intent to intimidate because of race. 37 requires only a willful interference with a person's secured rights, not motivation based on rights. So I would suggest they're not duplicitous.
And along the line of duplicitousness, assault and battery. Many, many assaults here. Each of them have to have the intent to be because of one's race. What do we think the jury, are we confident the jury knew that they had to be separate assaults for separate convictions?
I would suggest so. Quickly with regards to this. With regards to all of the convictions that Bratley had mentioned in issues 1 and 2, the judge did not give a separate and distinct instruction, which is unfortunate because he should have. But I think we're saved by Commonwealth versus Mamey, which is in my case. The prosecutor outlined in his opening and closing that there were separate and distinct acts.
But I get the shod foot. What's the assault? What's the Section 37 assault based on that's different from the other two assaults?
39.
No, I mean,
There's the assault is under 39, isn't it?
There's the 37 assault under 30.
I thought it was under 37, but I could be wrong.
Well, the assault and battery with intent to intimidate is 39, and the 37 could be the threat or threat of force when they were pushing him out of the driveway and they were following him down the street with the crowd, one of those people being Christopher Bratley.
So, all right, well, either one. I mean, how are we sure that that at best one of those assault and batteries isn't a lesser included offense of 39?
And I would suggest because the prosecutor in the case, when he outlined in his opening and closing, he talked about the first attack, he talked about the second attack. That's how he did.
And yet now you're talking about 3 acts.
Yeah, 3. We've got 3
He
acts
didn't
here.
outline 3 acts.
The prosecutor?
Right, you're saying he did 2 events.
I'm saying what he said, he outlined it as the first attack being the one in the driveway, and then he said the second attack was the more vicious one that happened outside the restaurant.
But you're just saying that there were 3 separate acts: punching the victim, calling the victim the racial epithet, and kicking the victim. And that those are the 3 acts.
I would suggest with regards to the acts, the first one is the one in the driveway, the assault and battery, is the push out of the driveway. The ABDW, there's only one kicking alleged from Christopher Bratley. That's the second beating. And with regards to the civil rights violation and the assault and battery with intent to intimidate, it's the civil rights violations when they're going down the street and he's not touching him at all. It's, the threat of force when they're going towards him, I would suggest.
Did the judge make that clear?
The judge said that, he said 5 times in his instructions, and then once in answering the question, that the indictments against each defendant had to be looked at separately, and with regards to each defendant, they had to judge them separately. He did not give separate and distinct, which I suggest would have been better. It just didn't happen in this case.
All right, thank you. Your time is up.
Thank you.